Thank you very much, Mr Deputy Speaker. I beg to move that the Public Interest Disclosure Protection Bill be read a second time. But before I start, I too wish to express the condolences of myself and my party to the family of the police officer who lost his life in the line of duty last night. Bristol Royal Infirmary, Mid-Staffs, Morecambe Bay, Liverpool and Gosport. As in previous debates, I recite this shocking litany of tragedies which have become household names to remind us all of what is at stake. In each of those scandals, there were those who tried to raise concerns and protect patients, but were ignored and often intimidated, victimised or even dismissed. Had they been listened to, lives could have been saved. Whistleblowing is an issue in many sectors, including financial services, as I'm sure we'll hear about later. But it is often the NHS and social care cases that stay in our memories due to the terrible impact on patients and their families. The very name whistleblower denotes a boiling kettle, denotes a sense of pressure and build-up until a valve releases. In many cases, the poor working practice or patient safety issues have been going on for a long time before someone is finally driven to speak up. This is because the whistleblowing landscape in front of them is littered with broken careers and indeed broken people who tried to do the right thing. Most businesses and organisations want to create a good external impression, to project an air of success and to attract more business. As Sir Robert Francis highlighted in the Mid-Staffs inquiry, this can even be a significant pressure if public services are competing for contracts in a market-based system. The temptation is to cover things up, to look good from the outside, rather than admitting a problem and trying to fix it. This immediately places the employee in conflict with their employer, who just wants the problem to go away. To address this power imbalance, it's necessary to protect and support whistleblowers so as to encourage them to step forward and raise their concerns, whether if I can finish the sentence, whether on patient safety, financial wrongdoing or environmental damage. I give way to my friend.
I thank my honourable friend for giving way, and I thank her for bringing this bill to the House. Does she agree with me that one of the important factors of this bill is to protect employees, many of whom who find themselves dismissed for other reasons because they have engaged in the practice of whistleblowing?
Thank my honourable friend for that intervention, and that is exactly the problem with the Public Interest Disclosure Act as it is at the moment. It's inside employment law, and the burden is put on the employee to prove that they have been sacked purely because of raising a concern rather than on the employer. And it very quickly, as I will come on to later, just turns into, as we would say in Scotland, a complete rammy. In the 5 years I've been in this House, I've heard politicians from all parties, including the previous Health Secretary, praising whistleblowers. But despite several debates on the topic and about the need for action, nothing has been done. Nothing has been done to provide the protection they need from the point at which they make the disclosure. And that is the critical thing, to protect them from damage, not to allow a system to pick it up afterwards. And during the COVID crisis, when we were out clapping NHS and social care workers, we heard just as many stories of intimidation if they raised concerns about PPE or staffing. When the Public Interest Disclosure Act, or PIDA, was passed 22 years ago, it was also a private member's bill. Now, I wish to express my thanks to the Clerk of Private Members' Bills in the Public Bill Office for all of his work, but I recognise this is a bill I have pulled together. I have no problem with this bill being improved or changed or developed to make it function. This is not a party political issue. Whistleblowing exists in every sector, in every nation, and it is the need to deal with it that we should recognise and try and fix. At the time, PETA was hailed as world-leading. But that was 22 years ago. And there are now better international examples, and it really is in need of a complete makeover. So what are the problems with it? Well, firstly, whistleblowers think it offers protection from the point they come forward, but it doesn't. It merely allows them to challenge their employer in an employment tribunal after they have suffered detriment, such as missing out on promotion, being bullied or threatened, or in a third of cases, even losing their job. As I said earlier, the burden of proof is on the whistleblower to prove that raising a concern was the only reason they've been sacked, rather than put on the employer to prove the opposite. It's rather unsurprising, then, that only 3% of tribunal cases are successful. 3%. 97% failure rate. And that's just the ones that actually go all the way to a tribunal. The litigation process itself also creates opportunities for further victimisation and intimidation, with breaches of confidentiality and threats of spiralling legal costs. Ordinary workers in most sectors simply cannot maintain the fight. The problem is, as PETA sits within employment law, it just turns into that battle between employee and employer. The original cause for concern that made them speak up gets completely lost, rather than investigated and action taken to fix the problem. This is actually the whistleblower's biggest complaint. The people I met wasn't even about their detriment or protection for them. It was the fact that after everything they went through, the issue was never investigated and certainly never dealt with. What I would say is it shouldn't have to be a risk. It should literally be a normal part of your work duty or your duty as a citizen to be coming forward and reporting something. This bill defines whistleblowing disclosures, but it also widens the definition of relevant authorities to include not just employers, but public authorities and regulators, as many whistleblowers report that when they have involved regulators, they have actually been intimidated in exactly the same way and have made no progress. It places a duty on all relevant authorities not to subject whistleblowers to any form of detriment, and indeed to protect them from detriment. But particularly, again, and I cannot come back to this more strongly, to investigate the concern and take action to prevent a recurrence. It widens the list of professions who may make a disclosure to those previously excluded, such as religious ministers and police officers. Consider the cases of child abuse that might have been prevented had priests and ministers been able to speak up. Or how much earlier the families of Hillsborough victims could have been told the truth and given closure. It also includes those who were not previously defined as employees, such as trainees, interns or volunteers. I'm sure all of us who've taken an interest in this topic are well aware of the 4-year persecution of Dr. Chris Day, who warned about unsafe staffing in his intensive care unit, only to be told that junior doctors weren't classed as NHS employees and that he had no protection. While this anomaly has been resolved, it highlights the traps that unsuspecting whistleblowers can fall into. In particular, the bill seeks to establish an independent body with statutory powers to oversee whistleblowing. In this, I have called it a commission, but I don't care what it's called. After his report into the deaths in Mid Staffordshire Trust, Sir Robert Francis established the Freedom to Speak Up system. But the National Guardian is not a statutory role, and the local guardians are trust employees who themselves may be put under pressure when investigating a case. And that exactly comes back to the point raised in an intervention earlier. There needs to be absolute objectivity and a determination to deal with an issue locally rather than it becoming a festering sore. In contrast, the Scottish Independent National Whistleblower Office was established as a statutory body in 2018 and published its draft standards for the NHS and social care last year. While devolved governments will develop whistleblower support systems for their public services, PIDA is the underpinning legislation for all sectors, including businesses and the financial services, and it just no longer serves its purpose. The duty of the Commission would be to protect whistleblowers and to promote the principle of whistleblowing in the public interest. Such a body would develop standards of practice for whistleblowing policies and procedures and monitor the compliance of organisations with those standards. Such standards would include how issues should be investigated, and organisations would be expected to show what action they had taken to address cases. They would stipulate prospective protection of the whistleblower from detriment from the point of making a disclosure, including preserving their anonymity and confidentiality. Many whistleblowers suddenly find themselves splattered across the local paper. The Commission would also seek to resolve cases and reduce litigation, which is wasteful of public funds and both expensive and traumatic for the whistleblower. It can provide advice to whistleblowers who do not have any other route to report an issue or who are not making progress locally. It would be able to issue redress orders to try and repair detriment suffered by a whistleblower, rather than just making financial awards. And it would include banning non-disclosure agreements, which often whistleblowers are intimidated into signing. Where staff have been subject to deliberate detriment, there would be the ability for civil action. And as in Australia, criminal charges would be available for the most egregious cases of whistleblower persecution. There are different ways to improve quality of a service, and whistleblowing should not be the main method of detecting poor practice, the squandering of public funds, or fraud. Just as audit is critical to ensure probity in the financial sector, it is also essential to detect poor clinical practice. In Scotland, we have had regular reporting against quality improvement standards for the most common cancers for many years. In the case of my specialty, breast cancer, I was involved in leading the development of them almost 20 years ago. This process identifies outliers who can then be supported to update their practice, but it also creates peer pressure to drive clinical improvement if you know that your performance is going to be shared at a conference openly, transparently, every single year. It is also important to normalise incident reporting and encourage a culture of routinely raising issues without the sense of conflict and pressure associated with whistleblowing. This is the aim of systems such as Datix in the NHS, in which staff record, review and seek to learn from all incidents, from minor to major, including near misses. There will, however, always be cases that cannot be detected by audit, such as alcohol or drug misuse, bullying or racism. For that, whistleblowers are essential. And for whistleblowers to speak up early and reduce harm, they must be valued, supported and protected.